Hi, everyone. I'm just going to wait 2 more minutes for a few more people to join, and then we can get started. Okay. Hi, everyone. My name is Sue, and I'm a commercial lawyer at Gladwin Legal. Welcome to my webinar on essential terms and conditions for running an e-commerce business. If you're here, you're probably here because you either have an existing e-commerce business or you're planning to open an e-commerce business in the near future. First of all, congratulations. That's very exciting. And second of all, you're in the right place because it sounds like you're doing your due diligence and taking the time to make sure you're legally compliant from the beginning. Now, I'm sure you're really excited about the actual product or service that you're selling, and the legals are probably not on that list of things that make you excited. I get it, that's fair. From a lawyer's perspective, though, it is definitely important, especially with startups and small businesses, because we often have clients that will come to us after there's a problem. And at that stage, it can be a bit complicated and a little bit costly, whereas it might have been a very manageable risk had it been dealt with correctly from the beginning. So making sure you're ticking those boxes and laying that groundwork early can save you a lot of headaches in the future. In terms of what we're running through today, it is only a 30-minute webinar, so we're not going to be able to cover off every single thing you're going to need for establishing an e-commerce business, but we'll run through some of the key things. So I'll run through registering a company and a business name, the basics of intellectual property, your website T's and C's, privacy policy, and just the basics of Australian consumer law. So in my opinion, e-commerce business is definitely the way forward. It's a great way to enter the market. There's low entry costs. There's lots of audiences worldwide, great marketing and advertising options, which aren't typically available to traditional brick and mortar stores. And from a legal standpoint, online retailers have a few things that they need to be mindful of just because of the nature of running an online store. So, for example, if you're running a traditional brick and mortar store, you have customers who are able to come to your store, touch the products, get a feel for what it is, and then purchase the product. To contrast that, if you're running an e-commerce store, you have to make sure that you're describing the products accurately because they can't touch and feel the products. And you have to make sure that the claims that you're making are not misleading, that you have appropriate repair and refund policies that are compliant with Australian consumer law. And that really comes part and parcel with your website T's and C's. And it all kind of comes into play when you're looking at the contracts and agreements that you're having developed. So as a starting point, you want to consider your both business name and company establishment. So I'll run through business name first because it's usually one of the first things people do. It's very exciting. You can come up with all of these creative business names that appeal to your target demographic. But when selecting this from a legal standpoint, it's really important to make sure that your business name isn't already taken by someone who's trading. So what I would suggest is that before you spend all of this money on packaging, on branding, on marketing, you go and find out whether or not your chosen business name is actually available to register and whether someone else is using that business name in trade and commerce. So what I would suggest is go on Google, have a quick Google search, see if someone similar to your business name is already trading. Go on ASIC, ABN Lookup. From a trademark perspective, look on IP Australia and also socials to see if someone doesn't have maybe it doesn't have a website, but might be selling through Facebook Marketplace or might be selling on Instagram. Just go through that process at the beginning, even though it's a bit tedious, to see whether or not there's already an online presence in existence with the brand name that you're intending to use. Now, the reason I say this is because if an established business exists that has that business name, first and foremost, ASIC won't let you register the exact same name. But the primary problem and the secondary problem, I guess, is that an established business with a business name that's the same or very similar to you, if they've been operating for longer than you, it might mean that you spend all of this money establishing the business, getting brand awareness, getting people really invested in your brand, only to be hit with a cease and desist letter because you're infringing on someone else's intellectual property. So that's why it's really important to do those searches early on to make sure that you're selecting this unique and distinctive business name. Now, the business structure is something for you to consider and really strategize. You will need to consider whether a traditional Pty Ltd company is what's best for you, or whether perhaps a sole tradership or a partnership is preferable. There are pros and cons of all of the structures, but generally speaking, there are advantages to having a Pty Ltd company. From the get-go, you get the advantage of it lending legitimacy to your business. So if anyone were to deep dive into your small business when they're assessing whether or not the product they're purchasing is risky, if you are a sole tradership, that may show that your business is quite small. Whereas if you are a Pty Ltd company that's registered for GST, it might make the business look a bit bigger. There are disadvantages. So there's a high cost to establish a company. There are some ASIC filing fees, the legal documents, usually a shareholders agreement or a company constitution. All of those will come into play. From an accounting perspective, which you will need to talk to your accountant about how beneficial it is to you, but you do gain the benefit of a company tax rate, which I believe is 30% for larger companies. So that's something to also factor in from a tax perspective. In terms of legal benefits, the biggest legal advantage that I would say you get from registering your company is limited liability. If the company does go out of business, the company shareholders wouldn't be personally responsible for the business's debts, which is really important. That's where the sole tradership would fail. All sole traders would be personally liable if that does happen. It's a bit of a double-edged sword because if you do establish a company, the company directors have directors' duties under the Corporations Act. So if you as a director breach your director's duties, and usually that involves some form of negligence, there is personal liability attached to that, but it's much more onerous than and much more difficult to establish as opposed to a sole tradership. For a company, the final thing you'd want to consider is also from a shareholding perspective. There are options to own the shares personally, or you can own them through a discretionary trust. The trust just adds an additional layer of protection to shield your assets in the event there's some sort of personal bankruptcy, for example. Onto IP. So just from the basics of IP perspective, intellectual property is probably one of the most critical areas for businesses, particularly if your business is heavily geared towards IP. So for example, if you're a graphics designer or you sell a software as a service, in those kinds of businesses, it's even more important. At a basic level, intellectual property is basically anything that's used to really distinguish your business from everyone else in the market. This can be like your brand name, your logo, symbols and images, those kinds of elements that are used in commerce. If you were to formalize your IP and register it, that would be a trademark. We've discussed a little bit earlier about the importance of choosing that unique business name. And part of the reason that I brought that up and how important that is because of IP and the risk of infringing on someone else's IP. This usually happens if you don't do those searches early on and see whether or not someone else is already trading under that name. you may be at risk of infringing on someone else's intellectual property. You should also be mindful in general of intellectual property laws when operating in the e-commerce space. So this means ensuring that you have licenses and permissions to use any copyrighted materials, product images, videos, descriptions, all of those. Just make sure you have the appropriate authority to publish those on your website. The risk is that if you do need to rebrand as a result of infringing on someone else's copyright, there's a lot of associated costs. If it's a physical product you're selling, you'd have to repackage, rebrand. There's also that loss of customer goodwill. So it's really important to get that right from the start. I also do want to clarify, there is a pretty key distinction between a business name and a trademark. So business name, when I just discussed it earlier, it's just something that demonstrates that you're operating your business under that name. It's not the same as a trademark. A trademark will give you the exclusive rights to use that name and stops other people from trading under that same name. So the trademarking process to formalize it can be a bit expensive, but it helps you enforce your legal rights against competitors and other businesses if they're looking to use or register a similar trademark, and it can deter copycats. It also allows you to license your IP and commercialize it, which may end up being quite profitable, something for you to consider depending on how much value that lends to your business. Let's go into a little bit more detail about this in the next slide. There are pretty much, so the formal trademarking process happens with an entity called IP Australia. There are two main things that tend to be registered when considering a formal trademark application. So firstly, you can register the word trademark. So that might be your business name, for example. And if you're successful, you get coverage for that particular word or phrase. This is the broadest protection and generally the most difficult to accomplish. So if you do choose to go down that path, you just got to make sure that you're meeting the elements set out by IP Australia. If you choose to register your logo, you're protected from someone copying that particular image and the overall impression that logo gives. So it takes into account the shape, the orientation, the configuration of that logo. If your logo is just a stylized representation of your name, your business name, you'll be sufficiently protected by registering the name alone as a trademark. However, if your logo is quite distinctive, it has a particular color palette or something very, very unique about it, then you can consider registering the image to get the maximum protection of your IP. Generally, we recommend registering a logo as a second priority, and if funds permit you to do so. Logo registrations are the most important for businesses that have quite a unique logo and something that's very important to commercially quite important. So for example, the M in McDonald's, that's very distinctive, even on its own with very specific colors. So that's very important. They want to make sure that nobody tries to copy that particular logo or image. When it comes to protecting your brand and registering on IP Australia, it's really important to note that you can't register generic words. That's why it's really important to make sure that you consider this at the beginning when you're branding your business. So you can't register generic words that are commonly used to describe your business. So for example, if you were running a grocery store, an online grocery store, you can't just call your grocery store online grocery store and try to trademark that. IP Australia would stop you from registering that because they don't want you to have a monopoly over using those particular words when everyone in your industry will probably need to use it too. So you're also prohibited from registering geographical names. And this one's important because you might not know that the brand name that you're trying to register actually is a place. So just do a Google search beforehand as well. Just make sure it's not a common location, because IP Australia may just block it based on the fact that it is even if it's a suburb, it's possible that they'll block it. If the brand name you're registering has a meaning in another language that's related to your goods and services, that can also block it from being registered. Things like, say, if you try to register Bella, for example, might get blocked because of how commonly that's used in association with, let's say, face cream. Those are the kinds of things you want to consider. And at the very beginning, before you start coming up with branding and slogans and logos, we will often get clients who come in well down the process of having done the packaging and the branding and really grown accustomed to a particular name, and then they realize they can't get a trademark for it, and it's very expensive to rebrand at that point. So something for you to consider before you go down that process. Once you've picked a name that you like and isn't being used or registered by anyone else, you then register the trademark with IP Australia. The trademark registration process can be quite long. It usually starts with filing an application with IP Australia. That would include putting in your trademark details, who owns it, whether you own it personally or your company owns it, or maybe you have a separate IP company that owns your IP. Whoever that owner is gets specified, and the types of goods and services that are associated with your trademark. It then moves on to the examination stage, which usually takes about 13 weeks from that initial lodgement. And that's where IP Australia reviews your application, sees if it meets the requirements, those requirements being that it's not descriptive, as I mentioned, of your goods and services, and that no one else is really using that exact same trademark. If they have compared it to pending and registered trademarks and it's all okay, it will go into the acceptance stage. They'll send you a notice of acceptance informing you that the trademark has been approved by IP Australia, and then it will get advertised on the Trademarks Journal. It then becomes public, and people have 2 months to oppose your registration. So any third party can come in, as presuming they have a valid reason to do so, and can say, no, actually, I don't want this person's trademark to be registered because it's very similar to my trademark, and customers and consumers may be confused by who's selling what. Assuming that no one opposes your trademark in those 2 months, you then get a registration from IP Australia, and that will remain on the register for 10 years, not 10 days, 10 years from your filing date. Okay, so website T's and C's. There are usually different types of agreements that you would need depending on what your e-commerce business does, but you would almost always need to have a general set of website T's and C's. So these are basically a legal document that sets out the permissible and prohibited conduct in using your website. So it would include clauses to protect copyrighted material, website content, IP rights. It tells visitors who owns the copyrighted material, what they can do with that content and information, and of course, it limits your liability through disclaimers. It usually also tells those who visit your website, whether it's a customer with the intention of making a purchase, or whether maybe it's a competitor who's looking at the products you sell, but it basically tells anyone who goes onto your website how they're allowed to interact with your website. It's really intended to apply broadly to anyone who goes on your website, whether or not they purchase the product or service. And if they do end up purchasing a product or service, that's usually governed by a separate agreement. So as soon as someone comes onto your website, they can be bound by these T's and C's and then go and transact or do something through your website. And it really allows you to set the parameters for people interacting with your website, and it lowers your business risk. So the key clauses that we generally suggest in a generic website T's and C's would be who it's intended to apply for. It outlines what is considered okay, what conduct is considered okay, what's not. It has IP clauses to protect your IP, such as copyrighting the material that's on there. Grants you a license to do anything with the information that's given to you by customers. So for example, if you're getting reviews and images from them, it grants a license from the customer to you so that you can publish those reviews. It usually gives you permission to terminate the services whenever you'd like as a business, and it also limits your liability. On the topic of limiting liability, disclaimers do play a role in that. Disclaimers are generally embedded in the T's and C's. They can also be standalone, but that really depends on how much of a risk the particular product or service is that you're selling. We would generally advise against standalone disclaimers from a commercial perspective, just because customers might see that disclaimer and then just get spooked. So disclaimers are usually very short. They basically say something to the effect of, we can't be held responsible for the accuracy of the content on our website. Information about copyright infringements might say something like, if textures and appearances and colors of our products, they may be different from the products that are delivered because of the customer's computer and computer settings. Those kinds of disclaimers are very, very boilerplate and are almost always in all website T's and C's. It's just very broad language. If you're selling a product or service, you'll generally need a separate agreement or a more comprehensive set of website T's and C's with the shopping terms. So if you're selling a product, your terms will also need to cover off the basics of how to place an order, the cancellation process, the payment structure, payment gateways, those kinds of things, the refund, repair, and replacement process, especially in compliance with Australian consumer law, delivery and shipping. So at what point does the risk fall onto the customer, information about the product itself, and dispute resolution. So we tend to put in something that says that mediation must be done first before anyone takes anyone to court. Those are very boilerplate things that are in shopping terms of a website T's and C's. For anything other than a product being sold, you'd need pretty much a separate business terms and conditions, which will really differ depending on the actual type of business that you run. They're usually provided through a click wrap agreement. So the customer clicks, I agree before proceeding to purchase. But it really depends on what it is that you're selling. So for example, if you have like a subscription model, think like Netflix, you would need one that has subscription payment terms. If you are running a marketplace, meaning that you have buyers and sellers interacting with your marketplace, things like, for example, Airbnb or Uber, those businesses would need two separate agreements, one interacting with users and one interacting with vendors. If you're selling a software as a service, for example, you may need tech-specific agreement. And so that would need to come into play as well. So it really depends on what it is, and it's quite tailored. So this is completely separate to that generic website T's and C's that I mentioned earlier. Privacy policy. So if your website collects personal information, such as email addresses, contact details, phone numbers, all of that, we generally would recommend having a privacy policy. Your privacy policy pretty much states what personal information you collect and how your business will deal with that personal information it collects. And it needs to reflect what's set out in the Privacy Act. It will typically cover off whether you sell information, whether you use the information for marketing purposes, all the specifics about Google Analytics, how you're going to store that information, particularly if your servers are located offshore. A privacy policy, similarly to your website T's and C's, it will apply automatically to anyone who goes on your site. And it sort of gives you that defensibility if a customer says, I didn't authorize you to send me emails, and you can point to that to say, actually, my privacy policy clearly states that I'll be using your email address for marketing purposes. You don't always need a privacy policy, and it's only mandatory if you have a turnover of more than $3 million, or depending on the industry that you're operating in, if it's very high risk area, such as medical or health related, you need a privacy policy. But I would say it is best practice. Australian consumer law. Australian consumer law is something that all businesses, small and large, they just need to be mindful of and to make sure that they're complying with. The ACL contains a number of consumer guarantees, which are these mandatory promises that you as a business automatically make to consumers. And that's regardless of any sort of disclaimers you put in your agreements or any sort of additional warranties that you may provide. These consumer guarantees can't be contracted out of. So they automatically apply, and you just need to make sure that you're aware of them. The ACL also includes a clear set of rules outlining what businesses are required to do if they do fall short of those consumer guarantees. So a few consumer guarantees there's one that says that goods and services need to be of an acceptable quality, another that says that the goods and services need to match any descriptions provided. Those are two off the top of my head. But there are a lot of remedies that are associated with those consumer guarantees if they do get breached. And that really depends on how faulty the product is, whether it's classified as a major failure or a minor failure. And you can look into that a little bit more detail as well. Just something to keep in mind is that under Australian consumer law, you're considered to be a manufacturer if the real manufacturer is located overseas without an Australian office. So that means that there may be times where you need to give the remedy to a customer, even if the issue seems to be a manufacturing fault. And you'd need to mitigate your loss with whatever manufacturing agreement you have with the manufacturer. Another perspective of Australian consumer law is also ensuring that you're not engaging in misleading and deceptive conduct. So this includes any misleading information on advertisements, even about the price, the quality, the nature, the appearance, shipping and delivery times. All of those things can be considered misleading. It also includes any conduct which might mislead consumers about their right to a refund. So in any website T&Cs that we draft, we tend to say, to the extent permitted by Australian consumer law. We just want to make it clear to consumers that their rights are not being circumvented with these website T&Cs, and to make it very clear that they have options available under Australian consumer law if you do breach the consumer guarantees. So that's really important. Something to keep in mind is that even if your intention was not to mislead, intention is not really taken into consideration. You may still be liable to pay penalties for breaching Australian consumer law, even if you don't intend to. So it's just really important to kind of have a good understanding of what it is that you're required to do beforehand. Yep, already covered that off. All right, that's it. We have pretty much hit time as well. So thank you everyone for attending. If you have any questions that have popped up as a result of this webinar, that's my email address. Feel free to email me your questions and I can take a look at it and send you a reply. Otherwise, you can also find us at the Gladwin Legal website. All right, thanks everyone.